Hello, my name's Michael Goodby. I'm a district judge in Adams and Broomfield counties in the 17th Judicial District. It's my privilege to speak today about the Victims' Rights Amendment in Colorado. I'm going to be calling it the VRA. Colorado voters amended our state constitution to include rights for certain crime victims 25 years ago, almost in 1992. At that statewide election, 86% of the voters supported the VRA. The Colorado VRA is located in Article 2, Section 16A of our state constitution, and I'll just read it to you because it's very short. It states, any person who is a victim of a criminal act or such person's designee, legal guardian, or surviving immediate family members if such person is deceased, shall have the right to be heard when relevant, informed and present at all critical stages of the criminal justice process. All terminology, including the term critical stages, shall be defined by the General Assembly. Now, Colorado was one of the earliest states to amend our state constitution to include rights for crime victims, and there still today is no federal constitutional amendment. The enabling statutes that are discussed in the Victims' Rights Amendment are located, you would think, in Title 16 or 18, but they're not. They're in Title 24. And I would refer you to 24, 4.1, 301, and the statutes that follow that. It would be wise as you start your criminal rotation to take the time to read them. And if you read them, it will become clear that the VRA does not apply to all crimes. It applies only to certain criminal acts. For example, murder, assaults, sexual assault, any underlying crime where it's a domestic violence incident. And the complete list of crimes that are VRA crimes is located at 24, 4.1, 302, subsection 1. Now, the VRA also applies to only certain critical stages, for example, bond hearings, sentencings, and trials. Now, the thing that I really want to get across today, and I'd like you to remember these words, and I'll say it again at the end, is the victim present? And does he or she wish to be heard? Remember that. Under the VRA, our courts have the responsibility to do the following things, and I'll summarize them for you. You need to state on the record a victim's objection to any motion that may substantially delay the prosecution, and that the objection was considered by the court prior to granting any delay. You need to acknowledge that a victim may be present at all critical stages of a criminal proceeding unless the exclusion of that victim is deemed necessary by the court. You should inquire as to whether the victim is present and allow that victim to be heard at any court proceeding which involves bond modification or reduction, a subpoena for victim's records, the acceptance of a negotiated plea agreement, or the sentencing or modification of a sentence of any person accused or convicted of a crime against that victim. You should make arrangements for the victim to appear by phone or use similar technology when that victim is unavailable to appear in person for the critical stages where the victim has a right to be heard. This includes victims who are incarcerated in your local jail or the Department of Corrections or the Division of Youth Corrections. You should inform the victim of the results of any court-ordered HIV testing. You should make all reasonable efforts to accommodate a victim upon the return of a verdict by the jury. You should determine the amount, if any, of restitution that needs to be paid to the victim by any person convicted of a crime. You should provide the victim with information to any entity responsible for victim notification after the defendant is sentenced, and, upon request, to notify the victim of petitions filed by sex offenders to stop their sex offender registration. Throughout the entire process, it's important that courts treat crime victims with fairness, with respect, and with dignity. If a VRA victim believes that their rights have been violated, they may file a complaint with the Division of Criminal Justice Victims' Rights Subcommittee. I've been privileged to serve on that subcommittee and served as the chair or the co-chair for the last 8 years. Now, the good news from this committee is that there are relatively few complaints filed against judges, only 25 complaints in 10 years, as compared to more than 100 for law enforcement and more than 110 for district attorneys. If the committee determines a basis in fact exists for a violation of the VRA, this committee can require corrective measures, for example, training or perhaps the formation of a policy. I'm going to list my top 10 recommendations for you under the VRA, and these are based upon my years of review of complaints against judges on that subcommittee. Number 1, in court, inquire whether the victim is present and whether the victim wishes to address the court at any critical stage where the victim has a right to be heard. Number 2, if you have a question whether the VRA applies, you may want to ask the deputy district attorney in your courtroom, is this a VRA case? The DA has VRA obligations as well, so they should have their case file marked and may be able to help you. Number 3, at a VRA sentencing hearing, ask, does the victim have a position or does the victim wish to be heard? Number 4, if you have a question about whether an event is a critical stage or VRA crime, again, take a moment to ascertain or err on the side of caution and ask, again, is the victim present and does he or she wish to be heard? Number 5, if the victim is not present, ask the district attorney if they wish to provide the court with the victim's input, particularly when there is a motion before your court that could substantially delay the case. Number 6, take reasonable efforts to wait for the victim of a VRA crime when a jury verdict is reached. On the issue of sequestration of a victim during the course of the trial, I would encourage you to read the case of People v. Coney, C-O-N-E-Y, 98 Pacific 3rd, 930, for a thorough explanation of rights versus rules. Number 7, timely determine the amount of restitution that may be due to a crime victim. Number 8, develop a process, perhaps with the district attorney, of how you're going to be notifying victims of any petition by a sex offender to cease sex offender registration. Number 9, remember that your tone of voice may read flat on the record, but it can make a very meaningful difference when you're speaking to people that are before us, particularly to crime victims and defendants and juveniles. And number 10, remember that being empathic does not automatically mean that you're biased. How you say things and the words that you use can promote real healing for people that appear in front of you. Use that power well and use it wisely. So I'll say it one more time, short and sweet. Remember this. Is the victim present, and does he or she wish to be heard by the court? So I want to thank you for your service as a judge. My direct contact information for you, should you wish to reach me, is at 303-654-3538. Good luck to all of you.